As for issue.
Was that the clerk?
Yes, ma'am. I muted him.
Please. Ms. Nelson.
Good morning, Your Honor. Kirsten Nelson on behalf of Shanna Gardner. We waive her physical presence today.
Okay, thank you. Mr. Clifton.
Thank you, Your Honor. Mr. Doug Clifton on behalf of Christian.
All right, thank you. Ms. Bridegan's also present. Okay, so Mr. Hathaway, the clerk, just handed me one is Ms. Gardner's notice of sworn affidavits in support. And so then there are two affidavits that are contained. I haven't had a chance to read that. I guess Mr. Hathaway pulled them in, so I need a second to read the affidavits. But I can, I guess, hear from the parties, because this was later, just so the record is clear, later in the day, yesterday, there was a request by the defense to put this case on for status, and obviously we're in the middle of trial. Was that a knock? Well, we're going to pause for a moment. Oh. Sorry, I didn't know what door that was coming from. All right, so there was a request to have this hearing. Subsequent to the defense request, I did get, and I have reviewed / read and reread a few items so that the court could be prepared for this hearing. The defense, after the request made by Ms. Gardner, filed a supplement to non-party witness and victim Kirsten Bridegan's objections and motion for protective order regarding the defendant's August 13, 2026 subpoenas, plural. So before we begin, I want to make sure that we are framing what the issues are before we just start arguing again. So I want to know, is Ms. Bridegan objecting to all subpoenas?
The answer is yes, Your Honor.
All right. Is there anything that, from Ms. Gardner's perspective, we need to take up before I address the objections to the subpoenas?
No, Your Honor. We followed the court's directive yesterday to not file papers in opposition, but we are prepared to respond if the court has questions as to our position.
Okay. All right, Mr. Clifton, I will hear your objections so that we're organized. I want you to go subpoena by subpoena as to what the specific objections are by Ms. Bridegan.
Yes, Your Honor. And I'll start just overlay, because it's not necessarily just a specific objection to each subpoena. I mean, there's two subpoenas. But overall, our objection is that we have not been provided the information of materiality and why these subpoenas are necessary, which creates a situation where then we are arguing in the dark.
All right, I'll stop you there.
Okay.
For the record, this is the court's 7th hearing, I believe, on this matter. If it's just an overarching, you don't know why, I want to address that, and I believe the court addressed it issue by issue, okay, in its order as to why the court is requiring the production as it relates to the paragraphs from the initial subpoenas A and B. Do you have an objection to the call logs, which is G?
Again, Your Honor, and I don't mean again as in, I know I've made a lot of these arguments before. In your order, you state that there is a sealed in-camera submission identifying several specific alleged statements and subjects that this court finds satisfies the requirement of materiality. We don't know what those specific subjects are that they provided to the court. I'm unable then, or Mrs. Bridegan is in the position of being unable then to object to their either characterizations or the reasons why these subpoenas should not be issued. So in a normal circumstance, if they were going to subpoena call logs from, say, Verizon, I think the case law would say that I am at a loss to say that they can't get those. They didn't do that process. They are going after Mrs. Bridegan's phone to get that same information. I don't believe that it's the same, I guess is the best way to put it. And again, though, I don't understand the reasons why they would even be allowed that. And I couldn't find a case where, again, the majority of the time when you're dealing with subpoenas for phone logs, date, time, and all of those information, you're getting it from the carrier. I've done it. It's difficult to keep people from getting clients' cell phones for just that. There's arguments, say that you can find patterns.
Hold on. What is that sound? What is that rubbing? It's you. Okay. Clip it on your tie.
I apologize.
It's driving me crazy. Okay. All right. So
it's a different burden, we believe. And so, like I mentioned, in a normal circumstance where you're going after Verizon, I believe the case law is there to support that. I would have a difficult argument to object to that. This is different, though. And the main reason it's different is because I'm unable to object to say, well, no, that's not really to that, or that's not really for this, because I don't know what they're arguing.
okay.
It leaves us in the dark, and that is our main concern here. And I just, since we're on it, they have argued that, they need to keep their strategy to themselves and certain instances to themselves. They don't want to apply to the state. We're not the state. Mrs. Bridegan's a non-party victim in the case. It's not the same. It's not the same to say, well, yeah, the state probably shouldn't know what our defense strategy is, or at least little kinks of our defense strategy. That's different for her. We're not the state. It's not the same burden that to look at. And again, we don't have case law where people are pulling and extracting cell phone data off of a non-party victim's phone, specifically in a homicide. This is not a case where she's an eyewitness to say that's the person or anything like that, or that's somebody who did this to me. This is a non-party victim whose husband was murdered.
She's also a witness.
And a witness. But it's not this, it's not just any witness. It's a non-party victim. There are actually enumerated rights for her that is different than anybody else.
Okay, so I agree, and I have agreed multiple times with Ms. Bridegan's position insofar as this court has acknowledged multiple times her constitutional rights, okay? I think I've written it in the orders. I think I've verbalized it during hearings. That is solid, okay? And I believe in your paper you wrote that I said gray area. I say gray area because of facts, not law. The foundation of this country is the defendant's position, is the United States Constitution. Ms. Bridegan's position is a carved out Florida constitutional issue with overarching, just general constitutional rights, both privacy, that have long been a part of the foundation of our state and our country. So I am respectful of all of those things. I'm not in a legal, okay, in my mind, I'm not in a legal gray area. The rules, that is 3.220, have a subsection where there are situations that when the state of Florida doesn't necessarily disclose in certain A, B, C in that paragraph, and also situations where, because discovery is wide and liberal in the state of Florida, there may be situations where it comes to the court for resolution. Okay, I'm not in a legal gray area. What I am is in a factual gray area because I've never, nor have I found through my binding courts or other district courts a situation like this, meaning that I could look for cases right on point. But that's why we're all lawyers, and sometimes we have to navigate factual gray areas, and we have to pull from solid law. So let me know, I want to let you know, I want to clarify that. If I was unclear, I don't believe I'm in a legal gray area. I have to. Warren clearly states, okay, that it is court error, all right, and I think I've written this, court error not to do an in-camera inspection. If I just say turn it over, that is per se violation of this court's mandate. I have to do the weighing. I have to do the inspection. I have to do all of those things. And I went back and I read Warren again, and that's why I want to say we're not in legal gray territory. And then Roque talks to the download. I'll go back to Warren. But Warren, the trial court, and these obviously are different, but they were still, that is, the trial court was interpreting the Florida Constitution just on a general privacy right, because obviously the victim's rights were not a part of that case. But it's at Head Note 7, which appears to be, it looks like page 637 of the opinion. It says, when a person raising the privacy bar establishes the existence of a legitimate expectation of privacy, the party seeking to obtain the private information has the burden of establishing need sufficient to outweigh the privacy interest. Okay, and I'm going to pause there because Ms. Bridegan has a legitimate privacy interest, legitimate, maybe even more so than this case because it is written into our Constitution. So that being said, you are arguing, and I want clarification, you are arguing that you don't know what you're arguing against, but the defense in previous hearings has put forward that it is related to bias, it is related to motive, it is related to all of those things that would implicate both their United States Fifth and Sixth Amendment rights. And so what privacy right that Ms. Bridegan has would override those United States constitutional rights that would allow Ms. Bridegan to come in and hear what the defense arguments are, what they would intend to, what authority do I have to let Ms. Bridegan come and do that, other than maybe the general thing that you put in here. And I don't see that that would allow her insight into the defendant's Fifth or Sixth Amendment rights that are implicated within their arguments related to other witnesses. When Ms. Bridegan, if she was just a victim and she was not being called as a witness and there was no showing whatsoever, I don't know that I would have granted it because, I mean, it doesn't really make any sense, but the state has represented to this court that she will be a witness in the Gardner case. There have been showings at previous hearings that she's had and testified to in deposition without objection about her contact with other listed witnesses in the case, and some of it may be relevant, some of it may not, and there were no objections then when it was talking about the content. That's where I'm at a loss, that now because they're asking for paper or information independent of her testimony, that now all of a sudden she gets to know what they're doing and why they are doing it. That's my question.
Okay. Number one, in her depositions, yes, she answered their questions. I mean, that's what she was instructed to do. In her second deposition, the court actually instructed in your order that she put together that she put together information in order to answer their questions, and she followed the court's order. To now reverse that and say, well, you did it then, and now we should be able to search your phone. No, there's a line there. There's a
I'm
line.
going to stop you because I said lodge an objection if you thought, and you can bring it to me. I didn't say don't object. I just said that was a separate issue where it was allegations that she was feigning that she could not remember. That's why I asked. It was the feigning. And so I didn't, to avoid the possible request of a third, I just wanted it to be productive. And I also said you could object and certify whatever questions you thought were inappropriate.
If, just so I'm clear in the record, is the court stating that Mrs. Bridegan has waived her privacy rights by answering questions in a deposition?
No,
Okay.
I'm not.
Well, then her privacy rights still exist. And
Right.
so it still exists even though she answered those questions in a deposition. Answering questions verbally, going along with the information that they have, and again, Your Honor, everything that they're talking about that they need, they had in that deposition because they were asking her direct questions about records, about posts, about everything. That's how this all came about. So
Okay.
her privacy rights doing verbal is different than now they want to go into her phone.
Right.
Okay, and Your Honor mentioned gray factual area. I can't agree with you more. We're also in a gray factual area because it's not just their claims of bias and witness encouragement or however they put it in their motions that Your Honor just talked about. That's not the reason why Your Honor granted it, because we were making those arguments and there wasn't anything. There was an in-camera submission that states the sealed in-camera submission identifies several specific alleged statements and subjects that the court finds satisfies the requirement of materiality. That is where our issue lays, is I am unable to address those specific submissions that identify several alleged statements and subjects this court finds satisfies the requirement of materiality, because I don't know what they are. Mrs. Bridegan doesn't know what they are. So we're asking to be basically hand a phone over and let it be searched. We don't know the reasons why it's being searched, because a vague bias is not a reason for somebody to be able to search a phone. And so again, we're in that gray area of facts too, because we don't know what's there. And this is a different situation because again, the majority of the case law, when we're talking about in camera, here's the documents. Like, you know, I mean, it's something that's already in hand. And that's not the case here. In order to take that step, you have to, I mean, there has to be, I guess, a finding by the court that, number one, Mrs. Bridegan does not have a right and is not going to find out what the submissions that were provided to the court that were specific alleged statements that support the finding of materiality, and that based upon those submissions, the defendant's rights outweigh Ms. Bridegan's. And we just have not gotten to that complete picture of things, but I think now is, you know, since we're here, and we're kind of getting to the end of this after, like you mentioned, 7 hearings, that's really what this is about. So there has to be some type of ruling that says, number one, she cannot know what this is because that hasn't happened. And number two, that based upon these submissions, their constitutional rights, Mrs. Gardner's, outweighs Mrs. Bridegan's. And when we get to that point, I mean, again, I'm going to make the same objection. I don't know what the submissions are. But I think that's kind of the first.
What authority is there that says that Ms. Bridegan is entitled to defense theory? What scenario or case, civil, criminal, that a non-party could sit in and then make arguments related to something that has been identified and now ruled on as material, okay, to a defense theory? That's where I'm at a loss. I asked, which due process requires notice, which I've given notice every time, and right to be heard. We have been heard over and over and over again. I have identified, okay, the areas, and I said not everything, and that what I believe Ms. Bridegan is entitled to. based on the court's ruling. I have ruled, okay? And I think that's what's lost in all this. I have ruled. So now there needs to be compliance. There has to be some level of finality. Right, wrong, indifferent, there has to be some level of finality with this. And so using the Warren decision, using the Roque decision, not in legal, I'm not in legal gray area. There cannot be a wholesale turnover of her phone. And so what I have tried to do is painstakingly go over, and while I understand through the objection, I did not in this order say turn over your phone. I'm sensitive to that. People's lives are in their phone, okay? They are not entitled to that. Instead, I thought maybe we could piecemeal or extract just certain portions so she would have some level of comfort that I'm not even looking at it, okay? But there's an objection to that by the defense. And I found another case that says objection without solution. I can read it to you. That's inappropriate too. Just saying I object, there has to be some level of finality. And I believe it's in Warren that says it. Just saying I object, and then that's why I was trying to come to some solution, because I have ruled, okay? I have ruled, and I ruled a long time ago, and in my mind, and then I gave them only narrow areas, narrow time frames. If the Ms. Bridegan's position is that I don't want the defense, and you objected to the defense expert that I don't remember his name right now, but like the defense expert doing it, I said identify one that y'all were comfortable with. Then that expert that was identified said that he does not believe, same arguments that Ms. Stifler made yesterday, that like it can't extract just a piece. Then if that's the case, then I will go through it and just give them this small area of time from each area that I say, not everything from 4 years. Some of their arguments only talk about May 2025. Certain things only talk about that, and I will parse through it. What I think is fair, and I'm going to get to it from Ms. Bridegan's standpoint, is the whole phone, Mr. Clifton, gets given to her. And if you want to do an objection log based on my order saying, okay, this message from AB, okay, consider this, judge, this should not be a part of the disclosure. I think that's what's fair. That would protect her privacy interests without impacting Ms. Gardner's constitutional rights.
But, Your Honor, how do we make substantive objections to messages if we don't know what the materiality of any of these messages are? That is what we
I gave you clues. Any substantive message. Okay, so we'll just start with AB and LB. So I required a narrow set of communications between Ms. Bridegan and AB, Ms. Bridegan and LB from May 2025, plus any earlier communications specifically referencing Ms. Gardner, a charged case, jail, incarceration, testimony, emancipation, use of Bridegan's attorney, statements of the family members. So that is the clue. So if the message, let's say hypothetically, says, hey, AB, Gardner, and it pulls from whatever the search, Gardner, she's a terrible person. But the context is like, oh, just joking, blah, blah, blah. Then that is the objection. That should not be disclosed because the context of that particular statement is related to a silly whatever. That should not be given over to the defense. It doesn't have anything to do with her bias, prejudice, blah, 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 that I've already identified. And then I'll weigh it to see whether it goes or not. There'll be a tracking, a log, And then I will file all objections, and then it will be a part of the record and can go up, and maybe we can make some case law to give some other courts some guidance. I'm trailing a new path, okay? That's what I'm saying. But the metadata, the fact that they could have gotten it, we've been down that road. If it's on the phone and it hasn't, whatever, if it hasn't gone away, then there's no privacy rights in dialing a phone number. Like, it's the same thing. And as far as the AB and LB, on the fourth page, on those areas, if you want to look at it first, I'll give you a short snap count because we keep litigating the same thing. Object. Say that should not be disclosed. Judge, read 3 messages before. That was related to whatever. That should not go over. That's just a relationship, whatever. And I will make the call to say, because I know about the strategic things, and I could say, just like I would in any ruling, whether something comes in or it stays out, it's a judgment call by the judge. It's discretionary on me. And so I know the rules. I know the evidence code. I know discovery, okay? And it may or may not. And if it's private, if she wants to assert her constitutional rights there, assert them. But I only want to look in camera at the very narrow scenario that is before the court to allow, which the defendant is allowed to test the state's evidence. Witness testimony is evidence. Impeachment is wide. Extrinsic evidence could be used. I think they wrote in their papers at one point, I'm recalling, they said, well, we shouldn't just be confined to her answers in a deposition. If they know now that something else exists, and I don't know what they have, whatever, but like I have to handle what is before this court, which is a request. And I'm trying to handle it with as much care as I possibly can for both sides. That is what the law requires. So Roque says that when the court orders, which I understand, it's a government intrusion. It's and then that's a 196, and it says that there wasn't a dispute about privacy. We're going into 197, which no one is disputing. And however, when the government intrudes, okay, it has to be narrowed. And I'm prepared to do that. I'm prepared to respect Ms. Bridegan's rights, but I also have to give over what they would be entitled to. That's my job. So that is, to me, the fairest way to do it. They've apparently submitted affidavits that say that you could target. If Ms. Bridegan objects to that and the expert says it, give the whole thing, I'll give it to Ms. Bridegan. It's her phone. Then you lodge the objections in the areas where I've identified that should be turned over, and I will make rulings on those objectionable areas. That was my thought, based on what I read from you. But we're not starting from scratch, Mr. Clifton. I mean, I feel like I've given a pretty good roadmap, and I'll give it to her first, and you. You go through it, make a log, I'll compare it, and then after the log, I'll give them the opportunity to be heard. I'll make the call. Does that sound fair?
No, Your Honor, we're still, we're not agreeable to that. I mean, the bottom.
I've ruled, Mr. Clifton, so based on my ruling, I'm asking, do you want to exercise that process or not? I need compliance. You can tell me yes or no, if you want to object or not, the way that I'm outlining for you.
Yes, Your Honor, because this isn't just a blank objection. Again, our objection is based on unknowns. So yes, we still object to it because I can't go through records. I can't tell what is what if I don't know exactly what their materiality is to be able to respond to it. If Your Honor orders compliance and orders us to turn the phone over, I mean, that's Your Honor's order.
Okay, let me be clear. okay? Ms. Bridegan would never be allowed to object about relevance, okay? She is not a party. She can't object based on privacy. She can't say, oh, that's not relevant, I'm not telling you. She can't object on privacy. And the state of Florida's bowed out. They don't want to be heard about this. And so that is her legal ability to lodge objections to this particular piece of evidence. So whether it's relevant or not, or goes to their defense or not, that's not her obligation. We're like, think about it like you're in a depot, right? She can't say, I'm objecting. You're not going to, that's not relevant. But she can say, this impacts my privacy rights. And so looking in that lens, okay, based on the categories that I've given, that is where I need your input. That is where I need her to say, no, that's taken out of context. No, that impacts my privacy. No, they shouldn't get that, because that is her legal foothold in this whole situation. That's the way I see it. I've ruled, okay? I've ruled about this. And if to the certain extent, like the justice for Jared, I said it's very small areas that I like comments.
We were told by their expert yesterday that that's not even on the phone.
What?
That you have to get that through Meta.
How would they know that?
Because none of those DMs or anything are saved to an individual's phone. They're saved in Meta on the cloud, and that was his whole.
I thought I don't know what I was very clear about is that phone is not going to be used to log in anywhere, okay? So if it is or if it isn't, then if it's nothing, then it's nothing. There's no objection there. It's what is contained. They've asked for information on the phone, but the phone is not going to be used to connect to anything. It's just going to be whatever. So I don't know what Cellbrite is able to do now, but it's only what is actually on the phone that will be allowed. I'm not, Ms. Nelson, I hope that was clear.
Yes, Your Honor, completely clear from our perspective.
Okay, no logging into anything. It's just whatever is contained on the phone. And so this is the next question I have, Mr. Clifton, which is the defense has identified 2 individuals that say that they can target the areas within my order, or are you requesting the full download and you go through it and you lodge your objections that way?
I'm not requesting a full download because I don't think that's proper. I don't know who their experts are. I mean, that was just filed. I didn't review it, Your Honor. I didn't have time to do that. I guess the best thing I can say to Your Honor in order for us to move on is we are not in agreement to turn the phone over. So if Your Honor, it sounds like you are going to order compliance to turn the phone over to a certain individual on a day, we're just asking then for that order to take place. Because that has not taken place yet.
And so I just want to be clear. I understood from the other objection you're saying she has not gathered this information. Is that right? And that's why the phone's getting turned over? It was over. The other pleading that was filed is it's overburdensome. It's not, I guess, organized in a way. In order for Ms. Bridegan, I did not want to order the download, but I also need the information in some form. And so that's how we got here about the download.
There are particular documents that she put together for that second, on her phone to talk about that second deposition, and she testified all those. That's never even been requested. That's those specific information has not been requested. It's just a solid request that we want all communications from May 2025 and on. Not what we talked about in the deposition.
Is it a part of what I've ordered to be in camera reviewed? What Ms. Bridegan has put together?
It is, Your Honor. We requested the screenshots as part of our subpoena.
I don't have anything regarding screenshots, but there it is. I mean, so there is, I guess, a portion that she put together for Your Honor. I mean, that is there.
Okay. Has Ms. Bridegan complied with EF, turning that over?
Yes, ma'am.
Okay.
I mean, there's been, and again, I mean, because this idea of just objections and not saying anything, we're allowed to object. I mean, a subpoena came out and we objected to it. And that's what we're dealing with right now. If there's going to be an order, you need to turn over the X information that you talked about, these messages in that. Again, I mean, an order, I can't go through this order and just say, now we're going to give this, but hey, we're not giving this. Overall, we don't want a download of her phone. If there are specific messages that they want, send a subpoena for that and we will deal with it. But that, I mean, that has not been done. We're talking about a download of the phone, not specific, hey, please give us the whatever it was that we talked about in the second deposition.
I love objections, Mr. Clifton. That's what I'm up here for, okay? I love them. All right, but they can't be endless, okay, when there's a court ruling, all right? So those are the rules. Then when the way we got to the download is based on your other pleading. That's how I thought we got to the download. I'm not just coming out of the air saying, turn over your phone. Somehow we have to, it morphed into that at this last hearing. I want the information based on the order provided to the courts for an in-camera review.
The only information that has been compiled is what she testified to at the second deposition, Your Honor.
So how can we get this information without a download?
They can send a subpoena and I'll work on that. That's without a download.
Right.
Yes.
Okay.
That's like we did with EF, but that is different than us plugging in or saying, now, Mrs. Brady, you need to go on your phone and start taking screenshots of 3 years of messages. That's different. And so if we're just talking about the information that she specifically discussed in her depo.
I specifically addressed the 3-year period. I'm talking about May. I'm asking, is there a way without turning her phone over that you can comply with this court order? That is what I'm asking.
Not fully, no.
Okay.
And I think that's the issue then, because I can't, again, we get into like piecemealing things. I can't piecemeal it. There is information that has been compiled by her through the court order for the second deposition. Everything else isn't. So I can't just say, well, this is it, because that's not everything. This became because they wanted a subpoena for her download of her phone. That's what they filed in July. It wasn't my filing. I didn't say, hey, let's do download.
I know, but now we've progressed. So now we're in a more specific area.
Now they have filed an actual subpoena asking to download her phone. If the court is saying, we're not doing that, but you need to give her what you've compiled, like we did with EF, because that was the court's order. That's different than what is going on here right now, Your Honor.
Okay, I want Ms. Bridegan to comply with my order. And so if she was able to compile that, can she compile the things within the order? That's a yes or a no.
No, Your Honor, that is where we're going to get to overly burdensome.
Right, so now what is the solution without turning her phone over?
Hours and hours.
So now, compliance-wise, what is the solution without turning her phone over?
Our solution was to allow us to understand the materiality.
I've gotten past that.
I know, but that's it. I mean, that is our solution. So I guess we're at that point.
You can object more, I'm asking, how can you, if it's overburdensome, give me a solution that would not be so burdensome to Ms. Bridegan to comply with the court's order?
We don't believe that the court should order an extraction
I've ruled.
for the information of the thing.
I have ruled.
Then again, Your Honor, it's going to have to be just then an order stating that she has to hand her phone over to somebody for an extraction.
Your Honor, if I may, one of the 2 affidavits that we filed this morning is from another qualified expert at Invista, and the affidavits outline the proposed way that Invista could effectuate this type of extraction, and also a filter team process by which Jake Green, who was the person who appeared yesterday under oath and gave testimony before the court, would be walled off and would not have any access or direction or involvement whatsoever in the extraction, since that was a concern expressed by Ms. Bridegan's counsel yesterday. We've proposed a solution, Your Honor. We're simply asking that the court enter an order allowing Ms. Kayla Nelson, who is the professional from Invista, to perform the limited extraction of the applications the court has outlined in its order and outlined in our subpoenas. And Ms. Nelson is available and can be in Jacksonville tomorrow morning at 9 a.m. to complete the extraction.
I'll hear Ms. Bridegan on that solution.
Your Honor, we stand on, we do not agree with having an extraction of her phone. We believe it's a violation of her privacy rights. We believe that we have a right to know what the materiality is of what is being sought on her phone. I understand that the judge has already ruled on those issues. That is our position.
All right. I'll overrule the objection. Ms. Bridegan turns her phone over at 9 a.m. tomorrow. This court hearing is concluded.
Your Honor, I apologize. I just want to be sure.
I've got to start writing, Ms. Nelson. I got a jury back there. What is it?
I understand. I just want to make sure that we are giving Ms. Nelson the correct scope. So is it both subpoenas that have been issued by the defense?
Yes, with the correction, I went back through the order. I misspoke yesterday. I did say that everything, I'm going to just say everything comes to me in camera review, and I will review it and then release it from there. I did say yesterday that release directly to you, but I'm just going to do it in camera review of everything. And Mr. Clifton, you can, the offer still remains. Do you want to review the download after the fact to make objections to the disclosure that I would consider prior to any disclosure?
Yes, we want to be heard prior to anything going to the defense.
Okay.
Yes.
All right. It's going to be a short turnaround then. 9 a.m. tomorrow.
Thank you, Your Honor.